Hi, I'm Eric Knight, founder and president of Remarkable Technologies and proud UCONN graduate. Many times I get questions about my inventions. I have many inventions, and how do I patent them? How do I protect the intellectual property of the inventions? It's not as hard as it may seem to patent a device. The most usual course is to find a patent attorney and then bring the invention and usually a prototype to the patent attorney, and you work together with the patent attorney to come up with a draft application. But for many people that can be very, very expensive, and that may be, for some people, a daunting part of the task and not be able to pursue the product. Fortunately, it's not that difficult to file for a patent yourself. It's the process has been proven over 100 years. The paperwork and the forms necessary are free and available through the U.S. Patent and Trademark Office, and there are some great books that you can read that basically give you step by step. So I recommend maybe for the first one, if you have a number of ideas, maybe the first patent that you do, you work with a patent attorney or get some early advice. And you may be able to do most of it yourself after some of those initial consultations with the patent attorney. After that, you'll see a process that's involved where you can follow that same protocol and be able to file patents yourself. So I think it's something that anyone can do. It's not as daunting. Some of the skills you need, the writing skills are very important. So even though you're in School of Engineering, the writing portions that you take in your different course load are very important, not just for filing patents, but for things that you're going to do after school. The writing and communication skills are essential in almost anything in business. How do I know if something is patentable? That's an excellent question. It used to be that used to have to go to what they call a patent repository library and there used to be a couple of them here in Connecticut, and there probably still exists. But now there's so many online tools where you can do patent searches yourself. For instance, Google has a great Google tool. If you just go to Google and type in Google patents, you'll find the last, 100, 150 years of patents online through Google. And you can just do keyword searches to see if there's anything that's in your field that you think might conflict. So you really can do a patent search yourself using Google and some other free tools, but Google is a great place to start to get a sense whether someone has already created the idea or not, so you'll know right away whether you should proceed with your genius idea or not. Now, patents, first thing that comes to mind usually with an invention is to file for a patent on it, but that's not necessarily the only way to go. Intellectual property, the field of intellectual property is divided into different segments, and one is a patent, but another powerful way of protecting an idea is a trade secret. And a trade secret is really just keeping the constituent components and ideas to make the mechanism or device or formula to yourself. One of the most popular trade secrets is the formula for Coca-Cola. The Coca-Cola company has that secret very tightly contained within its company. They haven't filed for a patent, because if you file for a patent, you have to disclose everything about the invention, how to make it, and in very meticulous detail. In exchange for that disclosure, you get essentially a legal monopoly to produce the invention. But sometimes you don't want to disclose that much information, so people can reverse engineer thing and try and get around your patent. So sometimes having a trade secret on it, again, especially if it's a device I have, for instance, one of my inventions is a material that's kind of like concrete, but it's made of fibrous and recycled paper, and it's a solid type of a building material. Now this I would prefer not to file for a patent on, because I don't want somebody to know the methods and the ingredients that I use to make this, so I keep the method and process to myself. So it's basically a trade secret, and I could market this and have other companies, if they wanted to license the process, they would have to sign certain agreements to not disclose how they're making it as well. But it's also another way to go. One of the disadvantages of a patent is eventually the patent expires and it becomes public domain. So if you've disclosed everything, sure, you have this monopoly for a fixed period of time. It used to be 17 years, it's 20 years now. But after that, it's now public domain. If it's a trade secret, that can be a perpetual intellectual property, just again like the formula for Coca-Cola is essentially a perpetual piece of intellectual property. So that's a plus for trade secrets. Again, there's pluses and minuses and pros and cons of both, and a lot depends on the different inventions and the markets that you're going to pursue. one of my inventions, one of my most current inventions, is something called the UCONnator. It has a funny name, but basically it's a serious topic. If you go to a hotel room, for instance, and you want to know how clean your bed sheets or pillows are, this has a UV bulb that glows when you press this here. So basically it's like a flashlight that is combined with a UV LED. And it's not patentable, and it's not trade secretable either. However, the brand itself, UCONnator, is starting to catch on as a brand. And so UCONnator is a trademark, and trademarks are another form of intellectual property. Sometimes brand marketing can be as important as the physical device itself and its characteristics. If a name catches on and becomes embedded in society, and people want, hey, I want one of those UCONnators, the trademark itself, and I filed for registration of the trademark, so eventually the little TM, hopefully if I get the approval from the Patent and Trademark Office, will become that little circle R that you see to be a registered trademark. The name itself could be as valuable in that piece of brand as the intellectual property, as the device itself. So you really have to think kind of holistically when you're talking about intellectual property. The mechanism itself, the types of ways that you're protecting intellectual property, and also the brand development and how the brand can be protected and marketed. So it's really kind of, again, a quilt of different thoughts that you need when you're looking at intellectual property. One of the biggest mistakes, and it's just because people don't know, is if you come up with an idea for a product and you disclose it to friends and family, or you approach a manufacturer about it, well, the clock starts ticking. You have 1 year from that disclosure to file for a patent. After that, you can't file for a patent anymore. And I can't tell you the number of people that have come up with ideas that a couple of years ago, they had an idea, they made a prototype, they showed it to a few manufacturers, and now they're just getting around to maybe filing for a patent. I have to say, I'm sorry, you can't, after that 1 year period, and this is a hard and fast rule with the U.S. Patent and Trademark Office, that you can't file for a patent after you've disclosed it after a year. It's called the 1 year rule.